morning, Chattanooga. This is Jim McKoon and Clay Whitaker here today with Legal Bytes, another edition of our program to discuss with you potential issues in your life that can be addressed through the law, whether it's in your personal life, your family, or even in your business. And good morning, Clay. How are you?
You're good, Jim. How about yourself?
I'm doing fine. I had an early morning, had to run out and meet with the judge early this morning, and it got me thinking about a show we're doing today. I was getting a temporary restraining order this morning, and this one was a polite one. The other side and I agreed that we put down something to preserve the status quo while the litigation's going on. And, that's, you'd always like to see things work out that way between the parties, but sometimes you have to fight. But that is a tool that we have for our clients, is injunctive relief.
That's right, Jim. And that's a big topic, and a lot of those things related to injunctions, and certainly the most popular one, I think, or most commonly known one right now, is the Trump travel ban. An injunction, and there's actually been several of them that have been issued by various federal courts across this country related to the Trump executive order on particular types of immigration from certain countries. So people are familiar with that.
Right. I mean, you've had the state of Hawaii, and I think it was the state of Washington, and a couple other states now have all gone in various levels of litigation with the president trying to stop his executive orders with respect to trying to address what he sees as a security risk here in the United States.
So that's our topic today, injunctions.
Well, yeah, I think so. There are other tools, but I think an injunction is an important tool that whether it's just a husband and wife, we've got a statutory injunction in all divorces and domestic matters here in Tennessee. So they will be affected by an injunction. There won't be necessarily an application to receive it from the court because it's mandated by statute. But so injunctions affect husband and wives. There are injunctions that are involved in business litigation. If one of your key employees goes to another business and he takes out your customer list, and you've got an employment contract that says that he can't do that he can't compete, and he can't solicit away your customers or your other employees, you go in and get injunctive relief to stop that. And it affects all of us. And, it even affects us in sports. We're just mentioning the fact that Ezekiel Elliott is seeking injunctive relief to keep the NFL from enforcing its sanctions against him for basically damaging the shield of the NFL by his domestic activities.
That's true, Jim. So are we carrying on today with our new format? Any topic callers want to talk about can call in and we'll talk with them.
We are carrying that on. So if any of you out there have a topic of interest where you would like to talk to a lawyer, you don't understand an issue that's going on, and you want to call us, even if it's off topic, doesn't matter. We're happy to take your call. And Clay, what's that number?
800-8949 here at Nooga Radio. This is Legal Bytes, Clay Whitaker, Jim McKoon. We're from the law firm of McKoon, Williams, Ashley, and Stanley. We'd be pleased to talk with you about any topics.
Yeah, absolutely. So let's talk about this. There's another new use of injunctions that has just come out, and there's something been in the paper recently about that with our local district attorney general.
Yeah, Jim, that's a really interesting topic, and it is the so-called safety zone that's in Eastlake. This is a gang injunction. So for the vernacular, if you just wanted to call it a gang injunction, it would be accurate. It's been used across the country. The primary use has been in the state of California, and did a little bit of looking into the sort of history of gang injunctions. That's actually been around since the 80s. Certainly been used frequently in the 90s and has become very common in California, the state of Florida, Utah, and now Minnesota. And that injunction has actually been taken up by groups that have opposed it to the Supreme Court, and the Supreme Court of the United States denied the certiorari, the writ that would allow the court to actually view and to take on the challenge to that particular injunction. So it's an effective tool, apparently, for law enforcement. The reports are that it is a tool that, if used and tailored properly, can operate to protect the citizens in a particular area.
Right. And really what's happening is as I perceive it, and you tell me, because I know your practice is so much more criminal. And well, we have a call. Let's hold on. Let's take this call. Welcome to Legal Bytes, caller. You have a question?
Yes, I do. I'm right now going through a divorce, and I've got child support that's been attached, and I've kind of let it fall behind. What would be my best recourse in order to try to get it resolved? I've got a warrant out for my arrest, because of being so far behind in child support. What would you suggest being the best way to try to alleviate that situation?
Well, caller, is this in Tennessee or in Georgia?
It's actually in another state up north.
Okay. Well, and so typically in a situation like that, your primary concern is going to be the outstanding warrant. Typically what happens is once the warrant's outstanding, it gets on the computer system to the National Crime Information Center. Governor's warrant goes out. If you're arrested in another state, they can hold you. And under Rule 5 of most states have a Rule 5 or something similar to it. That's a rule that allows for extradition. And so you would have the right to challenge that extradition. But typically, you're going to be facing the opportunity to be present in front of the jurisdiction that issued that warrant. And, that's really something you can't plan for. If you get picked up at a time when you don't really know where you're going to be picked up at, make preparations for it. That's not convenient. That's not a good way to approach your legal problem. So my recommendation is, first is contact counsel in that jurisdiction. Make an arrangement to see first if you can have that warrant recalled. Sometimes the different jurisdictions have what are called purges, which allow you to pay a certain amount of money after showing that you have limitations on your ability to pay. And by doing that, if you pay that purge, you're able to get yourself out of the situation with the warrant. And typically the warrant's because you haven't really paid attention to your case, and these details need to be tended to. So what you don't want to do is continue to ignore it.
Right. I suspect, although you haven't told us, that if you're in a divorce proceeding, so you're on a temporary child support, you haven't been paying. There was a contempt action filed to enforce your child support obligation. You didn't appear. The judge then went further, set another further hearing, or usually called a show cause. At that point in time, under most states, they have to give you notice that they're considering it intentional and therefore criminal contempt. And if you didn't appear then or haven't appeared yet, that's why the warrants are out. And so this is really a situation where you're just not communicating with the court or with your wife's attorneys. And they need to understand if you've lost a job, if you just don't have the ability to pay, you don't need to be an ostrich and just put your head in the sand. You just need to talk to them, because there are ways to resolve that for yourself. If you just don't, you can't get blood from turnip, and if you can't pay, you can work things out so that your contempt can be resolved.
Does that answer your question,
okay.
caller?
Yes. Thank you.
Okay. Thank you for the call.
Good luck to you.
Yeah, bye-bye.
Well, Jim, that's back on the topic of divorce. We were talking a little bit about the way injunctions apply in divorces. In Tennessee, we do have injunctions that apply to our divorces, same things that occur in other states. Because of that, there's certain things you can and cannot do. The statute applies to every person that's involved in that kind of litigation. So it's unusual in that sense that the injunction actually applies to all of the litigants. But the idea is that you have to obey what the law is and what the law says about your divorce. You can't start acting in ways that deprive the other party of their rights in property, and that's what the idea is behind it.
It's not an order from the court; it is a statute. So we refer to it as a statutory injunction, and effectively what it does is it says we're going to maintain the status quo. So the way the marital estate existed and the rights of the parties existed on the day immediately prior to the filing of divorce is the way it's going to be into the divorce without court order. For example, you can't change your medical insurance beneficiaries and who's being covered on your own. If you have a need to change that because maybe your employer is cutting off the policy and you're not going to be able to provide a group plan for the family anymore, and you need to get that changed, you can't just call your wife and tell her that. You actually need to get the attorneys involved to make sure that everybody's understanding, and oftentimes we'll put down an agreed order modifying the medical plan for the parties to show. And the reason why you would want that is so that it's clear and there's not a miscommunication, and you don't have a contempt brought against you later for violating statutory injunction. Same with marital property. You can't just go out and sell cars or sell real estate that your spouse has a right in once the divorce action is pending.
That's right, Jim. So that sort of strikes at what we were talking about with the last caller, is that you can't do things on your own, make up your own rules, and act in ways that ignore what the court says. Once you get cases started where people's rights are particularly in jeopardy, that's the whole point of an injunction, is that it protects rights that might be jeopardized without the court having the opportunity to intervene in advance.
Right. And I have to agree with the commercial you hear out for another law firm in town that does exclusively men's divorces, where they say communicate by email. Keep a record. If you tell your wife, look, we just lost our benefits, I'm going to see what we can do, but the employer has cut those off, or I've just lost my job, or I just got a demotion, or anything that affects you financially, communicate that to her, but do so. If you want to talk to her by phone, do so, but do a confirming email, something where you've got a record of what's being discussed. We have another call, Clay. Welcome to Legal Bytes, caller. Do you have a question?
That other caller prompted this call because I'm amazed that they put a warrant out for child support, because here in Tennessee, my other half's ex owes her over $10,000, and I've been to court with her on 4 or 5 occasions, and I've never seen such a bunch of lip wrists. I mean, Maximus is, what is going on in this state that these women are getting screwed by husbands not paying, and the courts don't care? There's no warrants. I know one woman years ago, she said their husband owed them $25,000 before they threw him in the court. They slapped their wrist or they passed it. Oh, that's okay. Oh, don't worry. Oh, you only owe $6,000. And he said he was calling from Pennsylvania. In Pennsylvania, if you miss 2 payments, you're going to jail. So what is it with Tennessee that all these women are not getting paid by their bum husbands who owe child support?
Well, part of it is you just mentioned Maximus. So you're talking about a situation where you're looking after the government trying to recover funds where they paid for the child. You're not talking about a situation where the mother is going after the father of the child. The mother's involved, but her rights basically have been subrogated over to the state. And so you've got, what is it, Title VII?
Yeah.
A Title VII action where you've got the state trying to recoup. And so in that situation, the state has a totally different interest perhaps than the mother may have, because they're trying to balance their resources. They can't spend the monies that they would normally spend on one case. If they were the attorney, they have to split out their time, resources, as well as their financial resources over a number of cases, because there's so many involved with the state.
So it's typical of communism. It's like communism. That's why the Russian government failed. It's the state can't do anything. I always say if the state does something right, it's by mistake, because even a broken clock is right twice a day. Can she sue him individually to recover that money?
Yeah, she can sue individually to recover the funds she's owed. If she sues to recover all funds owed, then she has to reimburse the state what she recovers that the state has advanced.
Now, Colin, one of the things that is a factor that you may not be aware of is that, of course, we've got our constitutional rights in regards to how issues are brought before the court. If there's an individual person who wants to pursue their order that says that child support is owed, that person has to file a contempt petition, and you're entitled to it as a separate lawsuit. So many times people don't follow through. So you get the idea. So these funds build up. There's large arrearages that occur as a result of child support that's owed. But it's simply sometimes because the person who's owed the money refuses to file the separate lawsuit to enforce the order and go through the process many times.
Oh, no, she's done that. She's done that. Well, she's had him in contempt many times, and the courts just slap his hands.
It depends. And so many
That's
times.
Okay, we'll move forward. I went with her on 4 or 5 occasions, and I'll tell you what, it's a joke. It's a joke.
Caller, you just need to hire Clay Whitaker.
Yeah, if you'll hire me, I'll make sure the job is done.
Okay, bye-bye. Thank you.
Okay. Yeah, Jim, that caller's right, and that is an issue. But I will just say this: is that I find many times the problem is economics. People don't want to spend the money to get the money, and unfortunately, that's what you have to do. And you're right. If you want to hire the right attorney, you certainly can get that job done.
Absolutely. All right, so let's now get back to the gang injunctions that we're talking about.
Well, the gang injunction is an interesting one because it's triggered off of the idea that there's an area where the association of particular individuals that have been verified as gang members are not allowed to engage in certain behavior. One of the things is they can't carry guns in that area. There are also, of course, state statutes that would prohibit that activity also. But the other part of it is they can't associate together because of the likelihood of a nuisance.
So let me understand. If you have a permit issued by the state authorizing you to carry, you can't carry in that safety zone.
Well, I'm not sure about that particular part because it may be that since you are authorized, you might be able to do it. But most of the time, now my
gang member normally isn't a licensed.
Yeah, most of the time, a gang member is not going to go through the process. And this isn't every case because I'm sure that someone can come up with a gang member who's in fact otherwise law-abiding, that has a firearm and has been issued by the state and is authorized to carry it. Now, there may be other reasons why they might be denied, but I think there's probably that example is out there. But generally speaking, most gang members, at least if you have that association, you're going to also fall into the group of people who've had criminal convictions, may not be eligible to carry a gun, and certainly probably not looking to have the gun lawfully because of the use of that firearm is going to be for the illegal purposes that involve the gang itself.
Okay, so we've got that you can't carry the firearm in the safety zone.
Right, and so you're also not allowed to associate, and the reason is that the court's relying upon a petition that alleges what's called a public nuisance. And so the public nuisance recognizes that certain associations with particular groups. Now, in this case, it's gangs. In the future, it might be other groups. But right now, we're talking about gangs who are known to be involved in criminal activity, the use of intimidation, the use of violence to go ahead and further the activities and ultimately the goals of the gang, which might be control of territory for the purposes of distributing illegal narcotics.
So let me understand. What we're talking about is normally the police would be coming in after the fact. The crime has occurred and they're investigating the crime and they're prosecuting the crime and they're trying to find someone to arrest. Here with this, we're talking about a civil action by the city or by the state or by whatever the police authority is, a civil action to get an injunction over a certain geographic area where they perceive crime as a problem.
That's right.
So now they're able to deprive the people in that area of their First Amendment rights of association?
Well, no, because the actual petition itself lists a geographical area, but it also requires you to be a gang member. That is, you have to have, there's a analysis that's used by the Hamilton County Sheriff's Department, by the city of Chattanooga, that is a gang verification analysis. And so there's a number of things. It can be self-admission. It can be the use of tattoos. That typically means you've been in custody and have had your tattoos examined. So you have tattoos. You have the association with other known gang members. You might have convictions that associate you with those particular people.
Well, even Islamic detainees that we have had at Guantanamo and other places have had rights under our Constitution, correct?
Yeah.
Well, we're saying that because you're a gang member, you don't have First Amendment rights.
Well, no, I would say that you still have First Amendment rights. And so that's one of the objections that has been used in the other states. It's certainly being attempted to be used in our local resistance to this particular petition. But one of the things that I think is at least an activity that, or an attempt at least by the city to try to work on this is that they're trying to allege, and the county's trying to allege, that these particular gang members, so they've gone through a process where they believe there's a strong association with the gang. They name the gang. Those persons are particularly served with this petition. So you have to have service on the individual they're named in the petition, and it names the geography. So it's not just everyone in East Lake. In fact, the law-abiding citizens of East Lake are the beneficiaries of this particular attempt to, stop pre-crime. Sort of like that movie that we had not too long ago was talking about pre-crime, that the attempt by law enforcement to interdict the associations with these gang members and the way that they ordinarily would gather together is having an impact on their ability to carry on their criminal activity.
Okay, so I was trying to throw you that, but you handled that real well.
Well, I'm just copying what other smart attorneys have already said, Jim.
So there is no constitutional right to basically civil criminal conspiracy, and that's what we're talking about.
I think
their
that's a good way to say it. Yeah.
Their association is perceived by the law to be for the purposes of carrying out a crime or to plan crimes, and for that reason, their association is not constitutionally protected if that's established in the court.
I think that's a good way to say it. The other idea is just going back to the idea of what a nuisance is. And so, when we ordinarily talk about nuisances, it might be, and I think we've talked on other shows, let's say that you move to a neighborhood, and in that neighborhood there's a chicken plant, and the chicken plant has terrible smells, has hours where trucks come in and out, make noises. The plant itself is noisy. And because these folks have come in and moved into the neighborhood, that particular neighborhood may not have always been the same character as it is now. Many people would say, that chicken plant's a nuisance. We need to get it out of here. They might file a legal action trying to get the nuisance abated. Well, in this particular instance, it's not a chicken plant. It's a group of people who carry on activities like making graffiti, painting the neighborhood, selling drugs, having guns, using violence, prostitution, forcefully recruiting other members, preventing other members from leaving the gang. So, most of these things have to do with that other type of action. You mentioned the conspiracy. The typical way that we look at organized crime, and certainly gang members are organized in that sense, is the RICO action. While it's not a RICO case, it is the sort of activity that you might find in a racketeering case that shows this particular group of people don't need to be hanging out together and doing these things. And by doing that, if they are actually hanging out there, they're probably up to no good.
Okay.
So right now, the complaints are at least that here locally, this particular ordinance or this particular petition is probably not necessary simply because we decided not to enforce it. It's not actually been enforced. So, that's an argument that's before the court. I think it's scheduled to come up for further argument here pretty soon. But we're almost to the break, Jim. So we're here at 800-8949. You want to talk about any topic? You want to talk about injunctions? We're talking about that today. We'd love to hear from you.
Right, or if there's anything else. We've talked about domestic issues, contempt proceedings. If you have something on your heart or your mind that you need to talk with a lawyer about and you don't want to be too specific, we'll happy to discuss it with you over there. Or you can call us off there at our offices. Our offices are 756-6400. We'll talk to you after the break.
Tennessee Valley's news talk leader, Nooga Radio, digital FM 95.3 HD4 and 92.7 FM. Chattanooga Radio, digital FM 95.3 HD4, 92.7 FM's news now.
An 11-year-old boy crumpled by a hit-and-run driver in a black sedan. This happened at 3 p.m. on Dodson Avenue in Chattanooga. The police said the young man tried to cross the roadway when a driver coming the opposite direction hit him and then sped away before the police could get there. They're now trying to track down a black sedan. The young man in stable condition at the hospital. Firefighters in Collegedale were fighting a house fire when an explosion rocked the building, breaking windows and throwing 2 volunteer firefighters out the front door onto the front porch. They were taken to the hospital for treatment for minor injuries. The house fire was taken into control, and damage is still being estimated to cause the explosion, also being investigated. The man who was killed in an industrial accident in Dalton, Georgia at the Shaw plant has been identified as Jesus Pimentel. He was crushed between 2 pieces of machinery. Also subscribe to Radio News Talk 92.7 now.
Traffic, news, and information. Nooga Radio, digital FM 95.3 HD4 and 92.7 FM.
Your marriage is over. You've been abandoned. betrayed, you're angry, shattered, and heartbroken. Don't go it alone. When you are facing divorce, you need an experienced advocate to help protect your rights in the future. And you need it from a man with a sympathetic heart, but a hard nose. Attorney Clay Whitaker will fight for you in this most confusing and bitter time in your life. Clay Whitaker, 756-6400.
Nooga Radio, digital FM 95.3 HD4 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree. Call 423-800-8949. 800-8949. Nooga Radio, 92.7 FM and 95.3 HD4. News Talk Nooga Radio.
Nooga Radio, News Talk 92.7's Fast Forecast. Now, it's a sunny day in Chattanooga, getting up to 69 for the high today and 47 for the low. Temperature starting out at about 40 degrees. Tomorrow, partly cloudy, 71 for the high and 53 for the low. Tonight, getting down into the 40s, a chilly night tonight. Nooga Radio News Talk 92.7 and 95.3 HD4 is the home of the Sean Hannity Show. He's on every weekday from 3 to 6. That's your Fast Forecast now.
The Tennessee Valley's News Talk leader, Nooga Radio, digital FM 95.3 HD4 and 92.7 FM.
Welcome back to the second half hour of Legal Bytes. And during the break, we received a call. Caller, are you still there?
Yes.
All right. And how can we help you?
I just wanted to get some advice about potential litigation against stockbroker at a full-service brokerage firm in another state. A couple of questions real quick. It has to do with potentially suggesting unsuitable investments and recommending their own proprietary mutual funds and charting the account. And the question I have is the venue for the action. First of all, finding a litigator, would that be a criminal complaint, a criminal suit? And if I wanted to sue the person, would I have to go to California or New York where they're headquartered, or could I initiate a suit in Tennessee and have them come to Tennessee?
Well, first off, if you're with a full-service brokerage firm, then your customer account agreement will have a arbitration provision. Brokerage firms are generally regulated by FINRA, and you're required to arbitrate disputes with respect to your accounts through the FINRA arbitration proceedings. Those FINRA's arbitration office is actually in Boca Raton, Florida, but that's not where you arbitrate. You will actually arbitrate in your location generally, so that if you're dealing with a broker who long distance, then we'd need to look at your contract. But unless there's a jurisdictional provision, you would normally, if there was a need for injunctive relief, file it in the location where you would be, because he was dealing with you in this location. So you could argue this was the situs of the contract. You were getting accounts sent to your office here or to your home here. Dividends were being transmitted here, et cetera. So I think you'd have enough to be able to go in if you needed the injunctive relief, which is the topic for today. But after you apply for a temporary restraining order, if you needed one, then you're mandated simultaneously upon getting the TRO to also file your claim before FINRA. And so you'll be in arbitration, and that arbitration ordinarily, again, absent a jurisdictional provision in your agreement, ordinarily will be held somewhere near the situs of the customer. For example, I've handled FINRA arbitrations in hotels here in town. I've handled them in Nashville in hotels. Normally, a FINRA proceeding is not done in a courtroom. It's done in a conference room or some other similar facility in a hotel or a convention center in a city near you. And like I said, So I've done FINRA mediations here in Chattanooga, which are confidential settlement conferences. I've done that as well. So those can be handled here. That's something we do on a fairly regular basis, both for certain brokerage firms that we represent, as well as for individual investors that we've represented where we didn't have a conflict. So if that answers your question, you're not going to be in court, or if you are there, you're only going to be there for a restraining order hearing. After that, you're going to be in arbitration.
So that's the law with all securities firms, that they don't do business with you until you agree at the beginning.
I'm not saying it's not a law. It's a method of business. Again, I don't know who you're talking about, and I really don't think you should put it on the air. But most major brokerage firms, in fact, I can't think of any major or minor. When you're dealing with them, you sign a contract. Just like when you hire a lawyer, you normally sign an engagement agreement. Well, you sign a contract, and in that contract, you'll set forth your level of sophistication as an investor, how much money, a general statement of your status financially, and what kind of risk or risk adverse levels you have going into investments. That's all put into an upfront portfolio or profile with respect to you as a customer. And then you also have your customer contract. And in that agreement, there's ordinarily an arbitration provision that says that if there's a dispute between you and your broker, you will arbitrate it before FINRA. So again, pull out your customer agreement and look at it and see if you've got one. And if you wish to follow up further, I'd be happy to talk to you off the air. Our phone number is 756-6400.
Oh, okay. 756-400.
6400.
Okay. Well, thank you for your help. And would you be considered a litigator? Would you be somebody that would like to go to court, or are you one that wants to try to mediate and try to be conciliatory?
Well, I'm a litigator. I go to court, but I think all cases, if they can be settled, should be settled, because it's usually in both parties' best interest if you can find a resolution. But again, there's some cases that can't be settled for fair value, and so you end up trying them.
Well, and one last question, real quick. I'm funding to fund a lawyer like yourself. If the account has lost significant value to the point where you have no funds to hire a lawyer, how do you get legal representation? Is it basically you just don't pursue legal justice in that case?
Well, I mean, if you don't have the assets to hire an attorney, then yes, that a lot of times will happen because you're not able to engage. But if there aren't funds to use for a contingent fee arrangement, and if you don't have the funds to pay any type of hourly arrangement, then how else would the lawyer be compensated?
Oh, okay. So I couldn't hear you because of the phone in the background. But so you're saying basically, yes, you cannot get legal help without having funds, and therefore the funds have been depleted by poor recommendations on the part of the broker, and you've lost significant value in the account. You do not have any legal remedies if you don't have funds to.
You have legal remedies. You just may not be able to hire counsel.
Because that's what you need to do. Give us a call off the air. We can talk to you about the options that you may have.
All right.
Thank you. Thank you very much.
Okay, thanks.
All right. Well, we're trying to get back to injunctions and where we were.
We keep touching on all the areas where injunctions may apply, or some sort of relief from the court where you may have the loss of rights. And so, that's one big topic that the injunctive relief sort of deals with, is that the whole purpose of an injunction is that before you get to court in an actual lawsuit, you might have some irreparable harm that's been done to you, and you might need either to, as they say, have a prohibitory action by the court to enjoin someone from doing something, or you may have to have it mandated where the court is requiring the person on whom the injunction would apply to do a thing.
Right. And the difference is one, you cannot get a mandatory step or action of relief from a court in a TRO or a temporary restraining order. You can only get mandatory relief through a full injunction hearing. So that's a critical issue. So many times people walk in and with a TRO or a temporary restraining order to see a judge. I've seen a lot of young lawyers do this and ask the judge to give them a temporary restraining order requiring someone to turn over some property. Well, it can't happen. It's just not possible.
Well, so Jim, a lot of times, attorneys get I think a pretty bum rap, as you might want to say in the vernacular, where we file frivolous litigation and stuff. But, in this injunction law, there's quite a number of steps that are in the way that prevent the court from using this very strong, very powerful tool in litigation from actually issuing it. You have to do a number of things. Can we talk about that with the ladies and gentlemen who are listening to us?
Sure. I mean, well, first, when would you want the situation? We've touched on several of them. Let's say that
let's talk about Ezekiel Elliott. I think that's a pretty good way just to sort of deal with it.
Oh, yeah, I like talking about sports. Let's talk about Ezekiel Elliott.
Well, so he gets in trouble, and he's got a contract first. So football players have a contract. He's represented by the National Football Players Association. So he's got an association that looks out for his interest, but also deals with collective bargaining. So they negotiated a contract on his behalf. He gets in trouble. Allegedly, there's domestic violence against his wife or significant other.
Which has nothing to do with his own-the-job activities.
It's true.
But the NFL perceives that because of the fact that they have an image that they portray and have a consuming public that looks at these kind of issues and making judgments and decisions about whether or not to spend their money with the NFL, they are concerned that his off-the-field activities are going to damage their representation or reputation in the public because they are continuing to hire and use a wife beater, a woman beater, an abuser. And as a result of that, they take action through administrative proceedings within the NFL to sanction him and tell him that what he did was a no-no, even though you haven't been fully criminally adjudged for doing this. Our investigation says that we find that there's substantial grounds for that, and therefore we're not going to let you play for 6 games.
And so for the ladies and gentlemen who might not be a part of sort of collective bargaining or have agreements that relate to their employment contract agreements, in this instance, the action that occurred was not a lawsuit initially. It was an administrative proceeding based upon the agreement that there is between the NFLPA and Mr. Elliott and the NFL itself.
Right, and the Cowboys.
And the team itself.
The team actually has him under contract.
And so eventually then what occurs, Mr. Elliott says, you know what, I don't think this is fair. I don't want to be the guy that has to sit out these games. My team doesn't want that either. I've got a responsibility to them. So he files a suit in the United States District Court for whatever district they're at out there in Texas, and asks for a restraining order, asks for an injunction.
Correct. And what he's asking is basically that the court not enforce the ruling that was given down by Goodell and the others inside the NFL, and that he be allowed to continue to play.
Well, so you can see how the interplay between all of these particular agreements, the rules that are involved with the particular collective bargaining, the NFL's own rules, because it's a corporation and it has particular association and it's got different rules itself. And then you have the United States District Court has the power to act on behalf of all the parties interested and to stop the NFL from doing certain things. In order for that to occur, Mr. Elliott will first have to demonstrate that he's going to suffer some irreparable harm. Is that a fair statement?
Sure. He's got if money damages will compensate you for what someone else is doing to you, then you're not entitled to injunctive relief, because injunctive relief basically prohibits something from occurring to you, or alternatively maintains the status quo in your life. And if for example, I wouldn't get an injunction against someone after they ran into my car, I'd go after monetary damages because my car needs to be repaired. I've got a diminution in value of my car after it's been wrecked, all those kind of things. So I want my car fixed. And so I go after monetary damages. But where you're talking about something, he says, I can never repeat this year of my life. I can never repeat playing in these games. An athlete only has so many miles on his tires, and he's got to play while he can. And if I'm put out so that I have to really get in my earnings next year playing, I'll be a year older, and physically I won't be able to do what I can do this year. All of those kinds of things. And so for that reason, I am irreparably harmed if I am prohibited from playing based upon this unfair and invalid ruling by the NFL. I have never, ever been convicted of a crime. There is not sufficient proof to establish I've done that. If there had been, the government would be prosecuting me in the state of Texas. The woman would be suing me. I would be involved in, there would be other proof, and their investigation is nothing but a story. And they're doing that because they're worried about their own reputation and the shield, as they put it, and that's unfair to me.
Well, Jim, so we're talking about this topic. Before we flesh this thing out, anybody wants to call about any topic, we're here. This is Legal Bytes. Clay Whitaker, Jim McKoon, your host. Number's 800-8949. Give us a call. We'll talk about any topics today. We've had calls from some folks dealing with issues related to stockbrokers who may not be doing what you expect them to do, the issues related to contempt of court and divorce, those sorts of things. So if you've got any other topics you'd like to speak about, give us a call. We'd be pleased to talk with you. So, Jim, in order to get this off the ground, Mr. Elliott's got to file a complaint with the court asking for the injunctive relief. Is that right?
Absolutely. Well, and oftentimes you will couple your request for injunctive relief with other relief. I'm assuming that he's filed an action maybe for a declaratory judgment to have the proceedings by the NFL be declared void and invalid based upon the facts. But he's also asked that because of that, he's also asked the court to grant injunctive relief to prevent him from being harmed by not being allowed to play. And he has certain things he has to show. One, he has to file his complaint as could be verified or under oath. He has to sign the pleading, not just his lawyers, but he has to sign it himself under oath, saying that all the facts contained in the complaint are true and correct to the best of his knowledge.
Well, usually these have some temporality associated with the particular orders the court might issue. For instance, you could issue a temporary injunction, a preliminary injunction, and finally a permanent injunction.
Well, a temporary restraining order, and then a preliminary or temporary injunction, and then a permanent. Exactly. And ordinarily, depending on whether you're in state or federal court, you're looking at a 10, 15-day period on a TRO, or temporary restraining order, where they'll give you immediately. And the reason why you get that is, generally speaking, you cannot get notice to the other side before the harm's going to happen to yourself. So a lot of times, if that occurs, then you can actually go in and what's called ex parte, meaning without the other side being there and being present, being served, and apply to the judge for a temporary restraining order. Again, a restraining order can only be prohibitive. It can only keep the other side, who may or may not even be on notice at the time of the hearing, of taking action. And so you go in and you can get that, and you have to establish that there's based upon purely the pleadings, it is not an evidentiary hearing. It is on the record. So that sworn complaint that you, the client, have signed, your lawyer presents to the judge, maybe with a couple other affidavits if he's filed a separate motion or application for the TRO. And that'll be presented, and the judge has to determine that you've got a substantial likelihood of success on merits based upon what you've alleged, and that there's a immediate irreparable harm is there, and that without this TRO, you may suffer it.
Well, for the most of the citizens and our listeners, the most common way that you'll come in contact with something like this is going to be in the divorce proceeding, simply with temporary restraining orders, or even orders of protection might be considered in the same category.
No, that's true. I mean, you'll see, I know a lot of times people will file, when they file the divorce complaint, they'll also go in for TRO, allege that there's been violence or threat of violence in the home, and that the defendant, who's not there at the time that they're speaking to the judge, needs to be removed from the home and prohibited from returning. And in Tennessee, a restraining order is exempt from the normal limitations in domestic matters that exist in other civil litigation. So it will continue until further order of the court. I mean, so you're not limited by a time frame. You don't have to have a hearing to convert your temporary restraining order to a temporary or preliminary injunction. You just get it. And until the other side comes in and asks for an evidentiary hearing, it continues.
Now, Mr. Elliott, particularly since all these parties are involved, we know that he's probably gone the restraining order route, but then there's immediately following that going to be an evidentiary hearing of some sort related to the injunctive relief he wants.
Right. And I understand that at least it's my understanding that has happened, and they are right now waiting on a ruling from the judge, I believe.
So the judge might give that order, and then there may be requirements of things that Mr. Elliott must do, like post a bond, other things that might be required of the NFL as well. But I think you've already set out fairly well that the immediate harm is the issue before the court.
Right. And again, you point out that there's a potential burden on the party that's being restrained, and they could be harmed. And for that reason, our laws require that if you're going to be granted a restraining order or granted a temporary injunction, that the court has to consider the potential harm to the other side by restraining them or enjoining them. And as a result of that, determine what the potential exposure economically could be to the other side, and then issue an order that an injunction bond be filed before the injunctive relief is effective. Meaning, Mr. Elliott, for example, would be required to put down a bond of certain financial resources with the clerk of the court before his injunction would take effect.
I guess the concern for the NFL would be that the optics of this thing, as you've already said, might be so bad. It might be reminiscent of Ray Lewis and some of the other persons who've been involved with this. They may damage the reputation of the NFL, may cause other damages as a result of the issuance of the injunctive relief, and so have to put some money up.
Right, agreed. Now, what I haven't understood is if we're going to be fighting over something like this, why aren't they fighting over the Pledge of Allegiance? Why aren't we getting into a fight over whether or not these players actually have a First Amendment right on the job in the uniforms owned and licensed by the NFL and by the individual teams? They have a right to stand up or kneel or do whatever they want. And there's been no court action, no administrative proceeding, no anything. I mean, NFL's name's already been tarnished enough, so I don't know why they're worried about Ezekiel Elliott. They've got a lot of manure basically on that shield right now.
Sure. We talked about this in one of our last shows, and that the issue, is that I guess because the NFL has not acted, there hasn't been anything to enjoin yet. I mean, there's been some talks about it, but nobody's actually come out with an official policy. I think each team's been allowed to address it. And I suppose that depending on whatever the collective bargaining agreement says, and whatever relationship you have with your team, you might be able to make some action out. But until there's some action that's been taken that prohibits you from exercising your rights, you really don't have much to go on.
Right. And I think the owners and the NFL itself are scared to death to touch it. They don't know what to do.
Well, and of course, if you saw this week with the Texans and, the longer it lingers around, the more people say and do things that can be difficult. If you saw the owner of the Texans made a comment about prisoners and inmates and operating the team and things that might have offended people. Of course, the press made a reaction to that, and I think it's just a difficult situation for the NFL and for the team, for the Players Association also.
Something else that I guess we ought to touch on is once you get a restraining order or get an injunction, it can be enforced, and you enforce it through a proceeding before the court that issued it. Ordinarily, although I guess you could go to another state or to another district court if the property was located elsewhere, and you can enforce it through a contempt proceeding effectively, enforce the injunctive relief that you've obtained.
Locally, that's the idea behind our own gang injunction, is that the contempt proceeding would be the enforcement tool.
Right. I agree with that.
We've almost come to the end of our show again, Jim. It's been a good hour.
It has been. It's interesting topics, and we appreciate all the callers that have called in with their own individual issues. We've talked about potential claims against brokerage houses. We've talked about issues regarding criminal contempt and domestic proceeding. And we'll talk to you again next week over similar issues. This is Jim McKoon and Clay Whitaker. We're here with Legal Bytes, and we'll talk to you next week.
The Tennessee Valley's news talk leader, Nooga Radio, digital FM 95.3 HD4 and 92.7 FM.
If you've suffered a personal injury or a loved one was the victim of a wrongful death, give the lawyers at McKoon, Williams, Ashley, and Stanley a call. Our attorneys can help you or your business with a wide array of challenges to provide you with the highest quality legal services through the combination of our talents, experience, and expertise. If you're hit by business problems or need legal organization, we're here to help. Visit mwalawfirm.com. That's mwalawfirm.com. Give us a call at 423-756-6400. That's 756-6400.
Goss Insurance. Yes, we are local. And no, we don't have an 800 number. In fact, our mobile numbers are on our business cards. We live, work, play, and worship in Chattanooga, and we would love to help with your insurance. Business, auto, home, life insurance. Call now, save money. Call Goss Insurance for all your insurance needs. Goss Insurance, 875-2500. 875-2500.
Hey, Mom.
Yes, Summer.
I know what I'd like to do for Christmas this year.
What would you like to do?
Take shoeboxes full of goodies to the homeless military veterans.
What would go into these shoe boxes?
Toothbrushes, toothpaste, dental floss, deodorant, chapsticks, shampoo, soap, hand warmers, hand sanitizers,